Mock trial is a staged trial. It's exactly what it sounds like. You have a defense side and you have a plaintiff side. Both of us read from a pre-prepared case and prepare witnesses and attorneys for a staged court proceeding.
Joey Davis was 2 years old. He was full of joy, he was full of life, he was full of vigor and energy. He liked to play and run around, and he loved to laugh. He had a life full of possibilities ahead of him. But on August 8th, 2009, that life was cut tragically short. That day, Joey Davis swallowed 25 princess beads, a toy belonging to his sister. A toy that was coated in a chemical called 1,4-butanediol, a dangerous and illegal chemical. 2 hours later, Joey Davis fell into a coma, he stopped breathing, and he passed away.
Our executive board is absolutely student-run. We have no faculty advisor, no coach. There's nobody teaching us how to do this. Instead, it's students teaching other students. So that sets us apart from most other mock trial programs who typically have lawyers or professors helping them out.
Keeping that in mind, too. I mean, he's there just to prove that Joey was hurt, not because of the beads, but just the fact that he was hurt, which seems like the most mundane point to prove that he's a good story witness. That's why I think you should call it. I mean, it's too much fun.
Chelsea Kramer, my co-captain, and I worked together. We were on the AA AMTA team last year, being the first AMTA team that was made. So I've worked with her. I've worked with Matt Trefon for a couple of years now. He and I are very familiar with each other. We've been attorney and witness paired for a while. Other than that, everybody else is new game for me. AMTA is the American Mock Trial Association. They're the national organization of all undergraduate collegiate mock trial programs. What we do is we have an intramural program to start off the year where we train new talent and sort of ease into the case and start to learn it. Then we go to invitationals at other schools so we can get further practice. And then AMTA really comes into the picture. You actually start with pre-trial matters, which is where you'll discuss any evidentiary procedures, any questions for the judge about his preferences. Maybe you want to enter any evidence at that point. It's really just to establish how the trial should go as far as your constraints. Then you move into opening statements. You preview what the jury's going to hear. Then you go into the body, the plaintiff's case in chief. That's the side who has to prove everything in the case. So they'll call their witnesses. The other side gets a chance to cross those witnesses. You move on to the defense's case in chief, where they call their witnesses, and again, the other side has a chance to cross. And then you go into closings. You summarize what the jury just heard.
Now, Doctor, directing your attention to the portion of that law that says requisite intent, what is meant by that phrase?
Requisite intent simply means that a manufacturer acted with knowledge in dispensing a product. They knew that they were dispensing the product. That's it.
Opening statements are a preview of what the jury is going to hear in that case. You'll talk about your case theory as a side, what they should keep in mind throughout the entire proceedings, and you'll preview what you're going to talk about in closings. Closings is an overarching summary of what they've heard. You talk about the testimony presented, you talk about why your client is guilty or not guilty, or liable or not liable. The first thing you have to do is know that case inside and out, front page to back page. You just have to know the details in there instinctually. But what I'll do is, once I know that, you got to look over your directs to the point where they're comfortable. The direct examination you do, being the one with your witness, should be the most comfortable thing in your repertoire. It should be run to death and back, but at the same time, it doesn't seem rehearsed. And then, as an attorney, I would write my cross-examinations. It's important to go over those and know that you're probably not going to use them at any point, or they're probably going to change. And then speeches, it's pretty standard. I'll just work on memorizing them, again, knowing that I'm probably going to change them at some point.
To do that, we had to prove 3 elements. First, that Happy Land Toy Company violated a Midland statute or regulation.
A direct examination is one you do with a witness that your side calls. It's with a friendly witness, so to speak, in that the witness, you'll be asking him open-ended questions, and the witness will be eliciting testimony that you, on your side, want to hear.
And how are you involved in today's case?
I went undercover at Happy Land Toy Company and worked as the personal assistant to Mr. Blake license.
A cross-examination is questioning that you do of the other party's witness, a hostile witness, so you'd say. You'll ask close-ended questions, very specific questions, often nitpicking at details or trying to damage the other side's case.
You, of course, interviewed all these people, correct?
I simply reviewed the affidavits of those people that you've listed.
Oh, so you're saying you didn't interview these people?
Objection.
Witnesses are important because they're a bulk of where the points come from. You need a strong character on your witnesses. They need to know their affidavits better than anybody else. They need to know what's written in that case. And they really make or break the good teams from the bad teams. Before trial, every witness that's going to be called or could possibly be called has to be deposed and write down everything that's relevant to the case. So that's what the affidavits are.
The MDH has it in its power to order a cease and desist, to investigate and prosecute violators of the law, and to halt recalls of products if necessary.
Chelsea. Kramer.
Steve Michelin.
Joey Chrysler.
My name's Matt Trefon.
My name's Joey Cascarelli.
Kevin Schaefer. So what's your name? Kevin Schaefer. Each team will have a variable number of attorneys, but each side that you go on, plaintiff or defense, will have 3 attorneys on each side. One of those will open, one of those will close, and one will be what we call a swing. He or she just handles examinations. I was an attorney, and then on plaintiff, I was the swing attorney. So I just did examinations. I was really just there to prop up the other people in case they needed me.
I usually open or swing. I don't like to close.
Attorney.
I've actually only ever gone as an attorney.
I prefer going as a witness. It's easier for me and I have a lot more fun trying to get inside like the attorney's heads.
Usually I'm a witness. I tend to play the more quirky characters, the ridiculousness. Last year I did like this stupid Brooklyn accent kind of deal.
This is Penn Team 1. I've just learned today that we are Team Crab, as in Crab from the Harry Potter books, which I couldn't be more thrilled about. This is a Harry Potter theme, which means that all of the teams are named after things from the Harry Potter books. And apparently the people tomorrow from the Penn staff will be dressing as wizards, which will certainly help our reputation that Mock Trial is not an organization full of nerds.
So before every round we have one. It's just a chance for the captains to all be in one place. We send out announcements if we have anything we need to tell them about the rooms, logistics, how to get to places. And also before each round there's a captain's meeting in which they do like the witness draft. So the captains need to be able to find each other. And since we're sort of spread out over 3 different buildings, it's easier if the captains just leave together and then can call or text their teams. So.
The first round opponent, we went against Johns Hopkins A, which is their first team.
We are certain that no matter what evidence they present to you, they will not be able to meet their burden of proof. At the end of today's hearings, my co-counselor, Mr. Kevin Schaefer, will come before you and ask that you weigh the evidence presented to you today and find the flaws in the plaintiff's case.
They coated the beans in denatonium, which is the most bitter substance known to man. In their studies, no child could swallow more than one of these beads. Their faces scrunched up. They couldn't stand the thought of swallowing more than one. That measure was in place. Don't let emotions cloud your assessment of facts and judgment. Look at facts and evidence, and you'll determine that the Happy Land Toy Company is not liable. Thank you.
We are outside the tab room. I'm about to go find out how we did. I just got back out of the tab room, looked at our ballots, looked at our comments, and sort of gauged how we did today.
And how'd you do?
We ended up going 2-2, which is okay. I mean, it's 500 right now. There's a lot of areas we need to work on. We narrowly won a couple. We won a couple by a big margin. You know, we also lost one by a sizable margin too. So we're kind of, the judges are all over the place. We were a little all over the place. We got to focus for tomorrow. It was tough because we were waiting outside that tab room where they had the ballots, and once we learned we were 2-2, I made it explicit to Chelsea that as captains, our job was to tell the people what they could fix for the next day. I didn't want to burden people on our team with knowledge that they couldn't correct, anything about, you know, their level of skill, things that we couldn't fix in the short term I wanted to avoid. And that's why I was selective about what comments to give them. But I went back, we got him ice cream first of all. We stopped on the way back at a Wawa and picked him up some ice cream to raise spirits. And I really just think at that point we knew that we were better than what our record indicated, and I think that's what drove us the most. First round, second day, we faced, who did we face? Yeah, that's right. We faced Washington and Jefferson.
And you weigh it. Whichever way it tips, ever so slightly, you must find in that favor. At the end of today's proceedings, my co-counsel, Ms. Chelsea Kramer, is going to come before you. And she's going to remind you. She's going to remind you that the Happy Land Toy Company had a responsibility to the law.
Doctor, you mentioned earlier that you were involved in drawing up legislation concerning GHB, specifically Midland's health statutes of the criminal code. Would you recognize this statute if I were to show it to you this time?
Absolutely. There are several metabolic precursors to GHB. In fact, they continue to develop these precursors, and as such, we just issued a blanket statement and said any precursor to GHB would be illegal.
I'd like to talk about the financial situation at the Happy Land Toy Company. Now, in 2008, that was the first year you suffered a net loss, wasn't it?
What matters today is Joey Davis and the law. The law that Happy Land Toy Company broke. Find them liable. Thank you.
Welcome to the closing ceremonies for the 2010 Quaker Classic. The first from Case Western, Matt Vogler. The second, also from Case Western, Logan Stetzer. And the fourth and final witness with 18 ranks from Penn State University, Matt Trillin.
I'll remember the way this team improved when we got dealt a record that wasn't necessarily great, that was a disappointment, that was below the standards that we set for ourselves, and how easy it was for me as a captain, for Chelsea as my co-captain, to motivate people to pick it up. That second day we took all 4 ballots. You rarely see a team take 4 ballots in one day. So if I have to think about it, if there's a theme to this weekend, it was about overcoming adversity with new talent. People that didn't have a lot of experience, that they were really, they were breaking the mold and they were getting their experience, and they knew exactly what to do that second day.